Hello, thank you for joining today's Tribal Courts and Traditional Justice webinar series brought to you by the Tribal Law and Policy Institute in collaboration with our tribal training and technical assistance partners and funded by the Bureau of Justice Assistance. Today's webinar is titled Peacemaking and Indigenous Justice and Tribal Justice Systems and will be presented by Fred Jacko, an associate at the National Criminal Justice Training Center, and Catherine Retana, a tribal law specialist at the Tribal Law and Policy Institute. My name is Chantel Cloud, and I'm a tribal court collaboration specialist with the Tribal Law and Policy Institute. Before we get started, I wanted to note that today's webinar is funded by the Bureau of Justice Assistance, which is a component of the Office of Justice Programs, and all of the points of views or opinions expressed today are solely ours and do not represent the official position or policies of the U.S. Department of Justice. I will now turn it over to Fred and Catherine to introduce themselves and get us started.
Bonjour, welcome. My name is Fred Jacko, and I'm a member of the Grand Traverse Band of Ottawa and Chippewa Indians. I'm here on behalf of Fox Valley Technical College, who I'm an associate with. And I just happy to be able to participate with Tribal Law and Policy Institute to discuss peacemaking. Background is a lot of tribal court experience, probation officer and court clerk, did a whole lot of that sort of thing. And I'm just thankful to be here. Miigwech.
Thanks, Fred. And hello, everyone. My name is Catherine Retana. I'm a tribal law specialist and program manager at the Tribal Law and Policy Institute. Been here for almost 7 years now and been working with tribal justice system and CTES Purpose Area 3 grantees across Indian country. Come by way of UCLA School of Law. So my background is from a tribal law, federal Indian law background. And happy to share about some of the models that we'll be talking about today that we've connected through our work in the field with various tribal nations. So happy to be here and excited to get started. So first, I wanted to also talk about our learning objectives. So after today, participants will be able to understand peacemaking and Indigenous justice principles, explore cultural foundations and values, learn how peacemaking promotes healing and accountability, and then review promising tribal peacemaking programs and Indigenous justice models. Next slide, please. And now I'll segue over to Fred.
Thank you so much, Miigwech. And so, yeah, today's topic is peacemaking. And so to start with, we think about what peacemaking is when we refer to that term. It's a blanket term that we use in Indian country that refers to our traditional Indigenous practices and how we practice justice in Indian country. And so it's sort of this blanket principle, and it's been adopted, and that is sort of the common term for our Indigenous practices versus the European model that many nations practice as well. So they do all these practices do differ across the many nations that are in this country. But the goal remains the same, and it's restoring those who have experienced harm by others while reestablishing unity within the community. So there are some differences between peacemaking and the Western judicial system or the American judicial system. You know, the Western system is a two-party model. It's adversarial nature, right? So somebody's going to win and somebody's going to lose. That's a big part of the two-party model. The typical focus is to uphold law by punishment. You know, we have thousands of laws, and for each infraction you may commit, there is a pre-established punishment, and that is how the Western system chooses to restore unity in our spaces. The victim compensation in these models is secondary to the crime committed against the governing body. You have to recall that these crimes, although they may be committed against a private party, since it is the state or tribe that is the other party to the case, it is considered that they are the harmed party. And so what ends up happening is the true victims of these cases end up being secondary, which is not the way I would wish that we would do things. And so then we look at peacemaking. Peacemaking seeks to include all affected parties And that includes community members, the person that is the actual subject that actually was harmed, the person that created the offense, everybody, so that we can see the total picture, as it were. We emphasize outcomes that benefit the persons harmed in addition to upholding the law. We utilize community members from multiple disciplines to ensure the case is administered in a holistic approach. And what that means is we're seeking first and foremost to repair the harm that was created. So the big difference for me between peacemaking and the Western model is peacemaking is not adversarial in nature. Our goal here is to restore the people that were harmed, not solely to punish the person who committed the offense. And that is could be a subtle difference, but it really does change how we administer justice in these communities when we have that approach. Why should tribal nations consider peacemaking? First of all, it exercises our tribal jurisdiction. It's what sets us apart from the majority culture in America. It engages interested community partners in tribal justice, people that have good standing in the community that may otherwise not be able to be involved in these cases where their voices are needed. It encourages traditional practices and offers these practices within an expanded capacity to the community. And so this may be the first time a person has an encounter with our traditional practices is through a court case. That's very possible. And in my opinion, anytime we can expand those opportunities to involve our community members in their traditional practices and pathways is a good thing. Promotes positive outcomes for defendants by offering additional resources for the duration of the case. And this is critical. We want to recognize what has occurred in these cases, but we also want to repair these cases as much as possible. We want to return these persons to the community. And we do that by seeking to uphold them, but also to help them and to give them guidance and ensure that they understand how important they are to the community as well. Seeks to include the perspective of the impacted parties beyond typical criminal justice proceedings. And that's important. We want to see the full picture here, right? And so if we can include all of these voices, then that just makes it so that the case is better administered and that we have better outcomes for everybody involved. So peacemaking roles within tribal court. We're going to touch on all of these individually here briefly, but basically we have what's known as a talking circle, our sentencing circle, our healing circle, and our elder board. Talking circles may be used in cases where consensus is needed prior to adjudication, and so that's that time where we can get together in a circle and discuss the case and the merits of the case and the outcomes that we're seeking and come to an agreement before it has to go to adjudication. The talking circle is comprised of affected parties and community partners who agree to discuss the matter at hand and how best to reach compromise and harmony. The benefit in this practice for clients is choice and puts each person on equal footing with the other and requires that all voices be heard. And so again, we're stepping away from that two role model. This practice creates equality and ultimately that buy-in that we need for cases to be successful in the long term. If we have parties who are invested in the outcome and they feel like they had a positive role in creating that outcome, we're more likely to see the case be successful in the long term. The sentencing circle, used to build sentencing guidelines that the court may adopt in criminal and juvenile cases, occurs after pleas or verdicts are entered. Participants may include defendants, community representatives, medicine people, prosecutors, probation officers, family members, victims, their representatives, or other professionals the court may feel have an interest in the outcome of the case. And so this is part of, well, it can be part of a sentencing investigation, but the idea is to get that wide view through that wide lens. And so all these people that have a role in this case are able to meet again on equal footing and discuss it and discuss what is some of the best outcomes we could hope to see from this sentencing. Creates a sentencing order that protects and restores victims and gives the defendant the tools needed to correct their behavior and restores community unity and safety. And that is the ultimate goal with our criminal cases, right? We want to ensure that we restore the affected parties and we want to correct this behavior that has come before the tribal court. And so that's sentencing circles, I feel, are a great tool for really understanding these cases. The healing circle. The goal of the healing circle is to bring understanding, contentment, and a way forward in a positive manner for the subject. And so we're talking about it could be either party to these cases that needs this healing circle. You know, we get harmed in life and we need to take time to address those harms. And that's a great value of the healing circle. Seeks to give a detailed explanation of court decisions. And so in addition to trying to bring understanding, we also give this time to explain the court decisions and why they were the way they were and how we can cope with them. It offers participants the time and space to process the events that led to the court's involvement in their lives. So this is all about that big conclusion, right? Participants include the persons seeking the healing, the professionals assigned to the case, and community partners. And so that's the big goal for the healing circle, is it's kind of the big wrap up to a case, regardless of what the case was initially. And it just seeks to be that positive finish. And hopefully to create that positive lasting memory for these people that are involved in court cases versus a very common negative opinion of being involved with tribal court. This seeks to adjust that. The elder board. It's an invaluable method in peacemaking. It involves community members who are willing, our elders, who are willing to offer their hearts and wisdom to those who are court involved. It differs from circles in that the elder board hears cases and offers directions to the court and its orders rather than crafting agreements that the court may then follow. And what I mean by that is the elder board doesn't need to have a live case to work with tribal court and consult with tribal court. The elder board is there for the tribal court to connect with so that they can really have an understanding of their community they're serving. And it gives that insight, you know, what does the community want for tribal justice? What does the community want to see occurring in these cases? And how can we implement that? And so the elder board to me is a great tool to really create that community involvement and community buy-in, because it gives that actual voice from our elders to our officials that are practicing law in Indian country. So it's an excellent tool. May be used in many types of cases and offers the court real-time opinions from the communities it seeks to serve. And so it's a great option when we're talking about bringing peacemaking to a community. So we're just going to touch on some of the basic practices for our circles, and these can and will change depending on the community that is implementing them. This is based on my experience and the training that I've gone through for peacemaking. So typically we would open with prayer. We have the person who is overseeing the circle giving the purpose of why we're here, an explanation. Detail circle procedures. And so, you know, the methods that we adopt as a community, we need to memorialize those so that all of our circles are done in the same way when it comes to tribal court, because we do want to ensure that fair access to justice. And it does matter that all of these circles are done in the same way each time. Introductions of all of our participants. And so we know who's here, why we're here, and the purpose of our involvement in this particular circle. After that, we begin a guided discussion. You know, we do need to touch on certain topics in these circles. We need to ensure that we're covering all of the ground that tribal court needs from these circles. And so it is a guided discussion to ensure that everything is touched upon and that we don't leave anything out so that we get the best outcomes possible. After we have that guided discussion, and that typically looks similar to, we'll discuss the case, we'll go around and, how did you feel you could contribute to this? What could we do? How could we change these outcomes? How did we get here in the first place? That sort of thing. And so after we've done that, and we really feel like we've got a good understanding of what's happened and we know where we want to go, then we would conclude the discussion. And then we would go on to agreements and recommendations. And this is where we're putting it on paper. The circle met. We came up with these conclusions and these recommendations for tribal court. And here it is in this agreement that we've created. And then we have that sort of closeout where we check with everybody, make sure that we're doing well, that we feel like we've done a good service to the community with this circle. And we will close out with prayer and those affirmations. And hopefully it was a positive experience, given some of the nature of the circumstances. So areas to consider prior to implementation. Establishing peacemaking within tribal law and court rules. And so when we begin this process of bringing peacemaking to the community, we need to establish it. And so we could legislate it via tribal council, make it part of the laws for this particular tribal nation. The tribal court could establish it via court rule or administrative order. And I've seen it done both ways. What matters is that it is established and it is on paper, because that's what legitimizes peacemaking's role within the tribal court. Peacemaker training, this is critical. The peacemakers we're seeking have all of this knowledge, this community knowledge, whether it be traditional knowledge that they've grown up and practiced their traditional ways within the community, rather they're just an involved community member who has a big heart and wants to help. We want that knowledge that they already have, but we also need to equip them with the knowledge that's going to complement these cases. And what I mean by that is we need to know that the agreements that we're crafting are legally enforceable agreements. And so we do that by training our peacemakers so that they understand what they can actually agree to in these cases and what we can legally enforce. And so that training is critical. It's also critical because while you may have years of experience, sometimes it's good to have this extra training in dealing with the public, right? And so giving them the tools to make them successful and to feel emboldened to handle these cases is critical. Jurisdictional implications. We're going to find that peacemaking orders may not always align with outside jurisdictions, and there may be roads to cross when it comes to that, when it comes to enforcing some of these orders. And that's particularly one of the reasons why I like where we're using peacemaking in a sentencing circle, and then a sentencing order is adopted by the court. And that sort of takes some of that struggle away, because when another jurisdiction reviews these requirements within lien, if it's in Michigan or whatever criminal justice tracking system the state is using, they'll see these orders in probation as an example, and they'll make sense. If we don't establish them via sentencing order and probation terms, then sometimes you're going to have that static when it comes to working with outside jurisdictions, when you have clients that are living off of the reservation. So that's something to consider. Budget, got to have a budget. And so it takes a lot of planning to launch a peacemaking program. There's options for grants, so we can talk about applying for federal funding to get these going. We can go through the community itself to see if we can get a budget to explore these programs, but it's a big part of it, making sure that we have funding available to launch these programs. So community-based versus court integrated models. And so community-based peacemaking programs are those programs that are adopted outside of the tribal court, and then they seek to help and guide tribal court. And so they could be adopted by family services as an example. And so the roles continue to be the same. The big battle with these community-based programs is we have to get the court's buy-in. So it does require a lot of conversation and agreement between whatever organization is adopting this program and the court that it's serving. And so, governance and authority, of course, we have to know that the court is going to adopt these recommendations if it's not within its own, if it's under its own umbrella. And so that is definitely a consideration. Make sure we're establishing these procedural structures, our protocols, jurisdiction and enforcement. These are great programs, but if the court's not willing to enforce them, then we have a real issue there. And so it's all about that communication, right? Confidentiality and record keeping. If you're going to adopt this program outside of the tribal courts, we have to remember that we're probably going to be subject to the level of confidentiality and record keeping that the court has adopted. And that can be pretty rigorous. And so it's something to be aware of if you're going to try to adopt a community-based program. Having those confidentiality agreements in place and those record-keeping agreements, procedures in place is definitely going to be a sticking point. And then resource implications. It's possible that if you're outside of the course umbrella, there may be some funding restrictions there versus what you could adopt within the tribal court. Just, there's certain programs that are funded based on where they live within a tribal structure. And so that's important to understand and just be aware of. And so that sort of concludes our basic overview of tribal peacemaking. And so I'm going to turn over to Catherine, who's going to highlight some active peacemaking programs across Indian country right now.
Thank you, Fred. And we'll now look at several examples of tribal nation models in practice. These examples are not meant to suggest that there's one correct design. Like Fred mentioned, each tribal nation will implement peacemaking or indigenous justice in various ways, and it will be reflective of their traditions, their customs, and community needs. So really, these models and promising practices are intended to show the diversity of approaches that tribal nations are using. And as we go through them, feel free to notice both the common themes and the distinct features of each example. We really were looking to highlight various models, some that may be more formalized, some that are more informal, some that operate within tribal courts and tribal justice systems, some that operate outside of them, and also looking at various jurisdictional complexities, such as public law 280 versus non-public law 280 jurisdictions. So the first model that we wanted to look at today is the Navajo Nation. Next slide, please. In the Navajo Nation, we really wanted to highlight their peacemaking program because they are a program that really looks at formalizing their peacemaking program through their tribal code. And so if that's something that your tribal community or tribal nation is interested in, we would recommend looking at how Navajo Nation has formalized their peacemaking program into their code. And the Navajo Nation is often one of the most recognized examples of Indigenous peacemaking in practice. It reminds us that peacemaking is not only theoretical, but it is something that communities are actively living, teaching, adapting, and sustaining. And with the Navajo Nation, it really is something that through our work with the Navajo Nation peacemaking program, we've learned so much of how they incorporate Navajo traditions, principles, and values into peacemaking and how it's reflected in even day-to-day interactions within the community. And so I really wanted to highlight some of that amazing work that they are doing. A little bit about their community-based healing. The Navajo Nation program focuses on healing through traditional Dene Navajo principles and values of Hozo, harmony, and kinship within the community. And please excuse me for any of my mispronunciations, as I am not Dene. So I defer to the Dene people and the Navajo Nation for further information on these values and principles. But something that I've learned about Kit when I was working with the Navajo peacemakers is that it really is talking about kinship and how they relate to all living things within their community and their environment. And that is really reflected in the peacemaking program. This picture we have here is highlighting the Navajo peacemakers at the Tribal Law and Policy Institute's Tribal Healing to Wellness Park Conference in 2024, where they did a live peacemaking mock session and really broke down in a two-part workshop all of these Navajo principles and values. And it was amazing just to learn how interconnected their traditions and customs are with their peacemaking process. And really also with their approach in community education as well, because their peacemakers not only help facilitate this process with folks involved in the peacemaking, but they also go out into the community to educate the community on the peacemaking programs and how they can tap into being involved, and also going into schools and educating youth as well on how to become a peacemaker, which is really amazing, and something that we definitely wanted to highlight on our presentation today. And their peacemaking does offer an informal, non-adversarial alternative to formal court systems through consensus and dialogue. And the program, like I mentioned, is deeply rooted in those Navajo cultural values and spirituality, really emphasizing restoration over punishment. And even the selection of their peacemakers is a process that is extensive, because they really want to highlight respected community members that are very familiar with Navajo principles and customs, so that they can guide members through the process and then focus on restoring relationships and addressing those core issues, and also educating participants who may not be as familiar with Navajo values or traditions if needed. So definitely Navajo Nation peacemaking program is kind of the most common and very familiar program that most folks have heard about. And there's a lot of information on their peacemaking program out there. So I wanted to really highlight them if you're looking at a formalized peacemaking program, and also one that exists within their court system as well. I know that initially this was a program that existed within their judicial branch, and then they went through the process of changing that. And so if that's something that you're interested in, I'd recommend looking at their tribal code and finding out more about that process. And up next, we're going to highlight another Indigenous justice model, which is the Pokagon Band of Potawatomi. Next slide, please. So this slide highlights the Pokagon Band of Potawatomi Native Justice Program and includes an image of the interior of the Pokagon Justice Center. This example helps show how Indigenous justice can be reflected not just in procedures, but in program design, institutional structures, and physical spaces that reflect community identity and values. So if you see the picture, you'll really look at how the Pokagon Band of Potawatomi took the time to really reimagine this space and incorporating traditional customs into the physical aesthetic of the space where they were having peacemaking sessions, looking at a circular courtroom. They also incorporated a healing fire in a separate room where they can have peacemaking sessions as well, and really looking at symbolizing equality and cultural continuity. And this program really does use ceremonial traditions and talking circles to facilitate respectful conflict resolution within the community. It exists outside of the tribal court system. So this is a different model compared to the Navajo Nation. And these three program strands within the Native Justice Program focus on court integration, community conflict resolution, and education to promote harmony and healing. So although it's not within the court system, it is adjacent to the courtroom, but really looking even at when you walk into the space, incorporating a different approach than like a more Western court model. So we really wanted to highlight this practice because we wanted to really emphasize how Indigenous justice models can really look and feel differently in every community. And it'll even visually look differently based on those tribal traditions and customs as well. So the next Indigenous justice model that we wanted to highlight is some of the various models being implemented at the Tulalip Tribal Court. The Tulalip Tribal Court emphasizes various models of healing, accountability, and community balance rather than punishment alone. And these approaches align with many Indigenous justice traditions that seek to restore relationships and address the underlying cause of harmful behavior. They incorporate this through their various mediation services, talking circles, community involvement, and their elder panels that are rooted in tribal culture and in let me start again. Sorry.
You're
All right,
fine.
I'm setting up. So the next model we wanted to highlight, oh no, let me start again. I don't want to say model because it's various ones. So the next promising practices that we wanted to highlight come from the Tulalip tribe. The Tulalip tribe emphasize healing, accountability, and community balance in their tribal justice system rather than punishment alone. And this can be seen through their various approaches and models that align with their tribal traditions that seek to restore relationships and address the underlying cause of harmful behavior. This is incorporated through their mediation services, their community involvement, their various specialty courts, as well as their elders panel that are all rooted in Tulalip culture and incorporated into their various judicial processes. And this is a useful reminder that Indigenous justice approaches can be embedded across multiple pathways rather than through only one single program. And as Fred mentioned, one of their culturally distinct justice mechanism is their elders panel. This panel consists of respected Tulalip elders who meet regularly with first-time nonviolent youth offenders to provide wisdom, cultural guidance, and accountability. And their participation can lead to case dismissal or diversion if the panel's process helps the individual make positive changes. This is a traditional community-based alternative to standard adjudication that anchors justice in tribal values and teachings. And their mediation service is also a different model that they incorporate into their tribal justice system, where they provide a neutral forum for a dispute resolution that prioritizes reconciliation and community safety. They look at getting all of their mediators trained, and this has actually been very effective for their tribal justice system and has reduced the caseload for their tribal courts significantly. So we really wanted to highlight this practice as well, just given how successful it's been for the Tulalip community. The Tulalip tribe also incorporates a variety of specialty courts into their tribal justice system. This is through their adult tribal healing to wellness court, as well as their family wellness court. And they differ in that the adult tribal healing to wellness court is looking at substance misuse for adults specifically, while the family wellness court is looking at supporting the family unit as a whole. And they both incorporate traditional customs and values using mental, physical, and spiritual support. They also have a mental wellness court that's looking at supporting participants that have need additional supports for mental health disorders or issues. And they are not so focused on the substance misuse as much as the tribal healing to wellness court. So those are some of the various specialty courts that the Tulalip tribe has incorporated. And we actually were on a site visit where we were able to really connect with some of their various tribal justice professionals and really learn more from their tribal judges on what the impacts of these various models have been. So we really wanted to highlight some of the amazing work that they're doing in the Tulalip tribe. And if you are interested in learning more about some of the amazing work that the Tulalip tribe is doing, they actually are one of our mentor courts through TLPI's Tribal Healing to Wellness Court Mentor Court program. So feel free to reach out to us and we'd be happy to share some of the resources and connect you with them as well. So this next model is the Chickasaw Nation Peacemaking Court. And we wanted to highlight this model because this is looking more at incorporating the peacemaking model into a court system. And the peacemaking court at the Chickasaw Nation is incorporated in the court system in the way of it could be done through a court referral or a self-referral. So both options exist. But also if the peacemaking agreement is implemented through a court order. So we wanted to really highlight this as a more kind of blend of a Western court system and a peacemaking model approach. And they still incorporate Chickasaw traditions and values to resolve conflicts through community dialogue. And this is really done, again, through their selection of their peacemakers, making sure that they are respected members of the community, also familiar with Chickasaw traditions, customs, and values. And their guiding principles in their process is really respect, humility, compassion, spirituality, and honesty. Their process is voluntary, like I mentioned, but it can also be something that can be suggested through a court case, like a custody case as well. And it does emphasize healing reconciliation and strengthening tribal identities. Like I mentioned, another way that they implement this integration with the judicial system is that they document and integrate the court agreement or the peacemaking agreement into the formal court system through the court order. So this was a model that we wanted to highlight. Here's a picture as well, where we had the Chickasaw Nation peacemakers attend the American Indian Justice Conference in 2024, where they were sharing some lessons learned from peacemakers. And if you want more information on that, feel free to reach out as well. And we also have some great sample forms that the Chickasaw Nation was so gracious in sharing for folks that are interested in learning what their forms look like. We do have those available as well on our website and if needed via email. And next, we'll go to the next slide. So this next model is the Kanaitsi Indian tribes circle healing process, circle peacemaking. I'm not going to try to pronounce their program name because I would surely butcher it, but the meaning of their program name is coming together as one. And the Kanaitsi Tribal Court was looking at blending traditional Danaina customs with formal legal processes to address varied cases respectfully. And their circle peacemaking process encourages open dialogue and respectful communication to foster consensus and healing in disputes. And they honor those traditions by engaging elders and emphasizing dignity, honesty, and community involvement. Their model also integrates traditional justice with informal systems to uphold their tribal sovereignty and promote healing. And we wanted to highlight one of their practices in their circle peacemaking process is using a talking feather to help facilitate communication amongst participants. And this is a picture of the talking feather that they use in their circle peacemaking process to give space to whoever is communicating and allow for active listening amongst participants and still incorporating traditional custom into their process. And this is something that was developed by their community in response to their community needs. So we wanted to highlight a more community-centered approach in how they want to resolve conflict or foster dialogue and consensus among their community members. So in addition to the models that we've highlighted today, I wanted to share some resources on peacemaking and Indigenous justice. Like I mentioned, the Tribal Law and Policy Institute has been working with some of the various models that we highlighted today and have a variety of resources that were provided from them on walkingoncommonground.org/resources. That includes the forms I mentioned from the Chickasaw Nation. But in addition to the resources that TLPI offers, I wanted to highlight some additional resources from some of our tribal training and technical assistance partners, such as the Alaska Tribal Justice Resource Center, which has Circle Peacemaking resources, and NAR's Indigenous Peacemaking Initiative that highlights a variety of tribal codes as well as various resources around peacemaking and the various models, and also highlight the program page for each of the models we talked about today in case you're interested in learning more about each of their Indigenous justice models and how they operate. Thank you all for being here today. And if you have any further questions, feel free to reach out to us at wocg@tlpi.org. You can also check out additional Tribal Law and Policy Institute resources on our program website, www.walkingoncommonground.org, or our main TLPI website, www.home.tlpi.org, where we have additional resources in various subject matter areas. And we hope this webinar offered useful framing, practical ideas and examples of how peacemaking and Indigenous justice can support more holistic and culturally grounded approaches within your tribal justice systems or communities. And I want to thank you all again and pass it over to Fred for any additional thoughts.
Yes, thank you. I'm very honored to be able to participate today. Again, if there's any questions or concerns, I'm available through the National Criminal Justice Training Institute at Fox Valley College. And just very grateful to be able to participate today. And I wish you all well. Miigwech.
Thanks, Fred. And again, thank you all again for all the work that you do in support of your communities and healing and well-being. And if you have additional feedback, thoughts, or suggestions, please scan the QR code to provide us with feedback through our evaluation. We really do appreciate all of your generous thoughts and feedback and ideas and suggestions that you provide for us today and incorporate them in future webinars or training. And with that, I pass it over to Chantel.
Thank you, Fred and Catherine, for presenting this important topic during this webinar today. And thank you to the audience viewing this webinar titled Peacemaking and Indigenous Justice and Tribal Justice Systems, the second in the series Tribal Courts and Traditional Justice. Again, if you have any questions, please contact us at wocg@tlpi.org. And again, please take time to use the QR code to submit an evaluation on the webinar, as it will help us create future webinars and will be greatly appreciated. The first webinar in this series is titled Promising Strategies in Tribal State Intergovernmental Collaboration and may also be viewed at walkingoncommonground.org. And again, you may also visit home.tlpi.org for other relevant information and resources. And thank you again for viewing this webinar today.